Morning.
11252, Preventive Medicine Associates versus the Commonwealth.
Good morning. All right, let's proceed. Morning.
Thank you. Good morning, Chief Justice Ireland. Good morning, Justices of the Court. My name is Tim McGuire. I am here on behalf of the defendants and appellants, Preventive Medicine Associates, Inc., and Dr. Punya Murtala Kishore. Dr. Kishore is present here in the courtroom with his wife. As the Court is aware, we have two issues that have been reserved and reported to the Court. I'd suggest that they are two issues of genuine first impression, not only in this jurisdiction, but in other jurisdictions as well. There are also two issues of constitutional concern that I'd suggest that are in dire need of clarification, that are in dire need of the establishment of a bright line rule so that parties, as they go forward, can understand what the rules are as we advance in this age of technology. Goes without saying, but it's important to focus on the specific issues that have been raised here, what they are and what they are not. First issue, whether the Commonwealth may, by means of an ex parte search warrant, search post-indictment emails of a criminal defendant.
And your claim, take us outside of the realm of this case, but if it would apply, the rule you would like would apply regardless of what the post-indictment search warrant was for. I mean, it could be a crime completely unrelated to the indictment. Is that right?
Correct.
So you're suggesting that once there's an indictment, the Commonwealth is limited in what it can gather with respect to other crimes?
I'm suggesting that what they're limited in doing is executing an ex parte search warrant.
Well, why do we call it an ex parte search warrant? I mean, most search warrants are ex parte, aren't they?
Well,
Is there something special about
There
an
is.
ex parte search warrant?
well, I think there's something special about an ex parte search warrant for an email account maintained by a third-party provider such as Google, which is the case here. I think that's the critical distinction in this case.
Why?
It's critical because if the Commonwealth is to be understood, what could happen here is they can indict an individual, then pursuant to some ongoing criminal investigation, they can go in, obtain an ex parte search warrant, seize that indicted criminal defendant's email account from a third-party provider such as Google. They can search it. They can then decide at some point, we're not going to go forward with any other charges. And at the end of the day, no one, including the defendant, will ever know that that happened.
You used a minute ago the word execute. Is that your problem, the execution of it or the obtaining of it? In other words, one could look at this as a two-stage process.
Well, I think it's both. It's with obtaining the warrant in an ex parte nature without any notice or opportunity to be heard and protect the privilege. Then we also obviously have serious issues with the execution in this case.
Well, let's assume the warrant was for your client's offices, ongoing investigation into other criminal activity, and they came in and they seized file cabinets and things of that sort. Same problem?
Well, no, because there we'd at least know what happened. There, this is one of those unique circumstances.
But you couldn't stop it. I mean, if they had the warrant, you couldn't stop it if they took your filing cabinet.
Well, we could go into court. We could first obviously work with the law enforcement personnel to make sure that privileges are protected. If that doesn't happen, we could come into court with a motion for a protective order or a motion to quash. Again, I think it's very unique circumstances here. There's not too many places where a party maintains privileged materials. And in this case, again, highly confidential. These are documents that are, involve trial preparation, defense strategy.
So a defendant gets charged gets indicted for burglary. And then a month later, while that case is pending, he's been arraigned, the state starts an investigation into a suspected murder that he had committed a year before. and they want to get his emails because of communications between him and some people he was involved in with the murder. You're saying that the state has to notify him that they're going to get a search warrant for those emails? Why? It has no bearing on the first case. And it's going to interfere with the Commonwealth's investigation. It's going to tip him off that they're investigating the murder case.
I respectfully disagree with that. First of all, let's say they were going to execute that search warrant on his attorney's office. Well, they were going to execute it on his home and seek documents or whatever. There, the defendant's going to know that it happened, right? They're going to execute the warrant. They're going to find out.
So it's the third-party piece of this that's concerned to you?
I think that's the critical issue
But
here.
it's not at all uncommon for there to be grand jury investigations which are continuing, and they could have gone by grand jury subpoena and obtained a Google account as long as they're not focusing on the crimes under indictment.
I think our position would be the same if it were a grand jury
So
subpoena.
your view is I'm trying to think what's precisely you're saying. You're saying that the Commonwealth cannot pursue a continued grand jury investigation to crimes other than those being charged when they are seeking emails of the target of the investigation?
Well, I'm not saying that they can't pursue an investigation. What I'm saying is they can't seize his emails potentially containing highly sensitive material.
Could I just go back to your initial concern so I can break it down? You're concerned that, well, the way this started, you make the claim, and it's supported by things in the record, that the judge did not know the reason for the search warrant. And in fact, if you look at the search warrant, it seems to be for an entirely independent, not previously indicted thing. The judge wouldn't know. Would it make a difference in terms of protecting privileged information if the judge had before her not one search warrant, but two? One relating to ongoing and clearly stating ongoing investigation, not previously indicted, and the other one, Judge, this one previously indicted, which is what the second one purported to do. Already under indictment for these very things. These things are a third party in the hands of third parties, and would at least alert the judge to the fact that there's an ongoing investigation of something already indicted, and that this information might be, would that be require additional opportunity once it's executed for a tank team or some other mechanism that would ensure that privileged communications weren't inadvertently revealed. Would that mechanism address your initial concern about who's there watching the fox in the hen house?
No, I don't think it would. Again,
Why
as
not?
long as the seizure, again, whether you're looking for, and in this case, I think there's no question, there were three things they were looking for. One of those things
Well, let's pass that and
was
assume.
evidence related to this
Just
pending
assume
charges.
that.
The other thing is, it's the fact that they're invading the sanctity of the email communications where,
Well, that's the
especially in
second
today's
step.
world where the bars associations, the ethics, have both told lawyers that you can communicate
That's
with.
step two. We're talking first about the first step. If we permit it, post-indictment search warrant, wouldn't it protect a potential defendant or an existing defendant's interests if the judge were aware of it and was aware that the third party might be holding information subject to privilege claims, so that you can get it away because it's an investigation. Maybe they don't want them to. Well, of course, here they did secure it, but and then you proceed to the next step. So the first part's addressed, and now we address the second step. How do you secure the release of privileged communications? So my first question
And I
is,
apologize if I'm not specifically answering the question you're asking. I think certainly if a judge, unlike in this case, had been aware, that certainly is a good thing. Does that resolve all the issues? I don't think it does.
So well, let's go to your second step then. How do you make sure that the communications aren't? You're really attacking the concept that getting a file cabinet and searching around, if you have a search warrant based on probable cause, it's unfair in these circumstances in this day and age to assume that otherwise private communication could be said to be in plain view so that they can be looked at by anybody. That's
Correct.
what your concern is, right?
Correct. And I think the filing cabinet, which the Commonwealth likes to spend a lot of time analogizing to and saying is no different, certainly I think in today's world, especially in this case with an email account, very different things. Number one, again, if they're searching a filing cabinet, number one, we're going to be aware of it.
Yeah, but you're not going to be aware of it. If they had gotten a search warrant for the emails before any indictment had issued, would you be making the same argument?
First of all, I don't think those are the facts.
No,
and
but my question to you
yes,
is...
I would be making the same argument. I do believe, especially in this case where there was a 2.5-year investigation going on, there was attorneys involved in dealing with, it would be my opinion that yes, in today's world, with the way that we communicate through email, that yes, I do believe that it should be protected. I don't think the court has to go there in this case because those aren't the facts in this case. But yes, my answer would be yes, it still
Well,
should
your
be.
position is that emails are special, right?
Yes, and especially emails in the hands of a third-party provider where the law, frankly, the Stored Communications Act provides that nobody may ever know that was, and consider where that goes. Once they go in, a defendant can be sitting at trial, having been already indicted, totally unaware that his email's been seized post-indictment, with all of his communications with his attorney, as in this case, including memos about how to respond to the allegations.
But doesn't that particular concern get addressed if you had a two-step process? In other words, you get the indictment, you get the search warrant, you execute the search warrant, because it's emails, before, if it's post-indictment, before the Commonwealth can search, then there is a notice to the defendant and some process for reviewing those emails.
Absolutely, and I apologize if that's what Justice Duffley was getting at. Absolutely. You know, if there's urgency in the case and the third-party provider is not cooperating, there's some genuine concern that the email needs to be secured first,
Right.
then absolutely they can move ex parte. But it's the next step, it's the searching.
It's the execution that you're concerned about,
Yes,
not the search
yes,
warrant
and I
itself.
apologize if that's what the question before was.
Counsel, before your time expires, maybe you'd turn to the taint team approach and whether you have a problem with that.
We certainly do, as we've set forth in our briefs and as we argued below, we do have a problem with the use of a taint team. I think, as the Southern District of New York said in the case that we've cited on our brief, United States versus Stewart, it is important that the procedure adopted not only be fair, but also appear to be fair to protect the public's confidence in the administration of justice. I would suggest that allowing law enforcement personnel to go through an indicted criminal defendant's emails and look, first of all, at every single one, which they're being allowed to do here, to look at the privileged emails does not inspire public confidence.
Sorry, are you saying that if there's an email from Mr. Berthune or if you to the defendant that the Commonwealth is reviewing those?
That's what the current order allows.
That's what the taint team can review.
Yes.
So there is no excluded category of emails?
Well, as you read the order, and we actually asked for clarification of this when we moved for reconsideration, Judge Quinlan did include, they can look at all emails except for those that have been previously identified as privileged. I may be using slightly different language, but that's what she said. We asked for clarification of what that meant because some emails had been segregated by the Commonwealth as what they believed were privileged. But here, they had this separate category of emails, which they already gave to their investigators, they've already been searching, called the detainted CDs, the ones they believed weren't privileged. We've gone through, and we've shown in the lower court, that even in that detainted CD, their process didn't work. There are numerous privileged communications, including incredibly sensitive communications.
Well, that may pose some problems for them if they try to use them, and it may taint the It may taint the case on trial, it may taint future cases, but focus on the ones that have been separated out as likely to be privileged. And Justice Gantz's question is mine. Are they being searched?
I think that's unclear as the order, and that's why
Well,
we
they
asked for
must have been
clarification.
searched at one point to get into that category, right?
No, word search. It's
Well,
a
they
word
could-
search
I mean-
for attorney names, anything of that sort, and anything that popped up with those words.
Well, I thought somebody had actually looked at them. You don't think so? You don't know?
Our understanding is they were segregated between, to some kind of search
It's
term.
word search.
But
Term search.
And is there a joint defense in this case?
a joint defense,
Do you have more than one individual under investigation, and is there a joint defense?
Your Honor, well, not to have to disclose that in court, but yeah,
Well, I
there
mean,
are multiple.
it's going to matter
Yes.
because
Yes, and it may affect.
then you have to worry about targets of the investigation speaking with each other about things that their attorney spoke to them. You wouldn't have to worry about that if there was no joint defense.
There is that concern here, and there's at least one party who actually intervened in these proceedings below in front of Judge Quinlan for that reason.
Counsel, your time is up. Thank you, sir.
Thank you. Thank you, Your Honor.
Good morning. May it please the Court. My name is Thomas Boshin. I'm from the Attorney General's Office, and I represent the Commonwealth in this matter. I'd just like to begin by answering the question that Justice Cordy and Justice Gantz just posed. Page 960 of the record appendix is the search protocol, and paragraph 5 says, within 20 days thereafter, the members of the team, that's the taint team, shall review all emails from the church Google email account and the PK Gmail account, which have not previously been designated as privileged. So I think, at least as far as right now in the amended order, the emails that have been segregated by the computer would not, at least right now, be subject to examination.
But originally, I mean, that's the second iteration of this order, isn't it? I mean,
Right.
didn't you had all this stuff before there was any order and initiated your own process to review, correct?
I think that's correct, but to explain, this is the second iteration of the order because the first order pertained only to the church, that is the employee's email account. This encompassed more, and there was...
Was it, as Justice Cordy just asked, was the segregation done just by search terms?
My understanding, based on the record, is yes, it was a computer program that...
Are you not involved in this case?
I'm not the prosecutor. I'm only handling the appeal, so I know what's here in the record, but I don't know sort of beyond the record many things.
Okay.
So I can't answer beyond what's there, but what is in the record, in the record shows a list of search terms, including attorneys' names, and even the words lawyer and attorney, in order to get this, I believe it was around 7,000 number of emails segregated out as potentially privileged.
And it's your representation that no one has looked at the substance of those emails.
That's my understanding. That's
I'm
correct.
sorry, as potentially privileged? What does the potential mean? That you are reviewing them to see if they are in fact privileged?
I think when the computer picks up, for example, the word lawyer, it would pick up an email which said, I wonder if Roger Clemens has a lawyer. That may or may not be privileged. That's why I use the phrase potentially. But I mean, if it's picking up Mr. Berthium's name in a to/from field, that's probably...
Okay, but there's a big difference between identifying those which are potentially privileged, which you look at to see whether they are privileged, versus identifying those which you simply do not look at. That is because it's to or from an attorney. Which one are you doing? Are you?
No, I'm sorry. I think that's exactly correct. And the only perhaps using the word potentially was not a good idea here. But when I used it, I only meant that the computer program has been over-inclusive and has taken out not just names of attorneys, but also the generic terms attorney and lawyer. You know, I think that it would be very unwise if there was an email to and from the lawyer for the Commonwealth to then start going through that email line by line if it's patently obvious from looking at a to/from field that it's not, or a subject field, that it's not something they should be doing.
So what is the taint team going to be looking at under this order? Now that these, we'll call them potentially privileged things, are put aside, no one's looking at those, what is the taint team going to be looking at?
The order provides that the defendants can give a list of search terms to help the taint team go through the emails.
These are the ones Not the ones that have been segregated as potentially privileged. These are all the other ones, the other 50,000.
That's correct. The defendants can provide a list of search terms. I don't think they're required to. I think it says that they may. But the order leaves it to the search team to decide the manner in which they're going to conduct this search of the emails that have not been segregated by computer. And
The taint team is, they're all members of the same employer, right? They all work for the Attorney General?
that's correct.
So everyone ultimately answers to the Attorney General.
That's correct.
And so is that the only alternative to having a paid master? I mean, there's something distressing about having, you know, the right hand and the left hand all attached to the same body, you know, operate under this this wall that is a very breachable wall.
Well, I think that a few points. First, this is not just sort of many of the cases are two prosecutors working, you know, perhaps right down the hall from each other who are subject to the wall. This is completely different. I understand it's the same office, but this is completely different divisions. I believe it's even different buildings. They're not reporting, well, they are reporting to the same supervisor in the sense that the Attorney General is obviously in charge, but it's not, you know, under the Medicaid fraud aegis that these two different teams are operating. And I'll also point out that
But you could have two law firms, for example. You know, you could have a law firm that's much bigger than the Attorney General's office and would never think about a production, you know, under a, you know, some kind of confidential, that one part of the law firm could look at, never talking to the other part of the law firm. I mean, the Attorney General is office in some sense is like a big law firm.
I understand the court's concern. I think, though, that two things. One is that there's a body of case law, and two is I think even the beginning of the preamble of the rules of professional conduct say that the Attorney General's office necessarily has to be a little bit different than a law firm. For example, it could pursue a criminal matter while at the same time defending a related civil case. The analogy to law firm isn't always perfect, although I do understand what the court is saying. I'd also like to point out that the procedures that Judge Quinlan put in place here are stronger than in any case that I saw or that the defendant cited, insofar as she's got more protections than I had seen in others. She has them unaffiliated with the prosecution. They have to sign an acknowledgement that they'll be bound by the order, which I didn't see in any other case. They have to agree that they won't share the information. Defense counsel can review what they do to make sure that there aren't any mistakes, and then the court has the final say. And a lot of courts that have worried about mistakes have cited the Noriega case from the Southern District of Florida. There was no provision that allowed the defense attorneys to screen the screener's work. So the type of mistake that happened there shouldn't repeat itself here. There are cases which say that the screeners are not appropriate, but the defendants cited, I believe, 7 of them in the footnotes in their brief. 5 of those pertain to law offices, and we don't dispute that law offices are different. The warrant statute says that they're different. The rules of professional conduct talk about summoning lawyers, but in terms of subpoenaing a private individual's material, the majority of cases support what the Commonwealth did here, and beyond that, Judge Quinlan seems to have gone further.
So what should be the path forward, not in this case, with regard to post-indictment search warrants for emails? What's the right process that the government needs to undertake when it seeks post-indictment basis emails of the defendant? I'm not trying to duck the question, but I think it will depend case by case, because the standard is obviously going to be reasonableness, and I think that's probably what Judge Quinlan was worried about here was reasonableness. And so, no, but the process, I mean, just starting right from the beginning. First of all, you file an application for a search warrant. Should the judge be specifically advised that this individual is under indictment and represented by counsel?
I don't think that would be required, but it may be wise, required in all cases, I should say, because a magistrate presented with a search warrant is to determine probable cause and particularity. So if the indictment bore upon probable cause or particularity, then of course the Commonwealth should put it in. If it doesn't, it may be advisable so that the court is aware of things, but I don't think it's required.
Well, should it be a two-step process? should there be a search warrant required essentially to seize the material, and a second search warrant or second order of the court directing or outlining the search protocols before any protocols take place?
I think this court left that question open in McDermott as to whether once the computers were seized, there need to be a separate warrant for searching them. I don't think it would be required in all cases. I think that the initial warrant could, in some cases, contain perhaps a protocol or an advisement to the court. Here, the second warrant did advise the court. Paragraph 42 talks about the pending indictments, and paragraph 33.
This is in the second
warrant.
Not the first warrant, though.
No, that's absolutely correct, in the second warrant.
Should the defendant and his counsel be given notice once the emails have been obtained and before they're searched?
No, I don't think so, and that's the whole purpose of proceeding by warrant, is so that the evidence isn't destroyed. Here, the defendant...
Oh, but no, they're
you've got the
seized.
evidence.
Yeah,
you
you've
seize
got
it.
it.
First step, you seize from Google or whatever, the third party. You seize the emails. You got them.
Right. The problem with notice is that even if this evidence is safe, evidence to which this evidence may have led may no longer be safe, because if the criminal defendant is aware that the Commonwealth is pursuing a certain direction or lead, then he'll also be aware of where that's going to take the Commonwealth next.
And change his conduct?
Could he change it? Conceivably, I think that's
That
correct.
would be a problem?
Well, it would identify, I take it would identify maybe other conspirators or the places where other evidence has been stashed, or, right?
That's exactly right. Other conspirators that we don't know about, other evidence, perhaps other time periods that we don't know
The defendant becomes aware that you have this information. I take it your point is the person might move people around, move things around, get rid of things.
That's exactly
Should there
right.
be a different rule, though, where, I mean, where you are seeking post-indictment materials that are truly unrelated to the subject of the indictment? I mean, I think there's certainly an argument that Category 3 here is fairly closely related to the subject of the indictment. But put that aside. Let's just say you were going after 1 and 2. Would you treat that kind of search warrant differently than one that did seem to implicate the subject matter of the pending indictment in terms of notice to the now defendant?
I'm not sure in terms of notice particularly, but I think in terms of executing the warrant and making sure conduct was reasonable, that would be necessary. In other words, if the Commonwealth is aware that there's an indictment, which it would be because this is post-indictment, I would think that steps such as those that are now being taken here, and I'm not necessarily saying these particular ones, but steps such as these would be very wise for a prosecutor to follow so that they don't end up transgressing the reasonableness bound.
Is the Commonwealth exempt from the Lampron rule?
No, I don't think so. And if we had proceeded by a subpoena, then I think that would come into play. But the Odgren...
Required
Is it your view that you can do exactly the same thing by a search warrant that you would otherwise be required to go to a judge for under Lampron?
I'm not sure here we could have proceeded by search warrant because the SCA, the Stored Communications Act, says that for particular emails, you need to go out and get a warrant. So unless the Massachusetts procedure were more protective, and I'm not sure just a grand jury subpoena alone would be appropriate.
I'm not referring to a grand jury subpoena. I mean, if you were only seeking information with respect to the matters under indictment, is it your view that you could use a search warrant?
Yes.
Rather than a Rule 17 subpoena.
Yes, I'm sorry, I misunderstood your question.
But
Yes.
your view then is that the Commonwealth has the ability to essentially exempt itself from Lampron through the obtaining of a search warrant?
Well, I think in many circumstances that may well be true. However, the jail calls, this court said that if you're going to... No, to answer your question, yes, I think that's accurate.
You think you are exempt from Lampron?
No. I think that if we're going to use a subpoena, we have to follow...
No, not if you're going to use. You think you can choose not to use and just take the warrant route?
Only if we could satisfy the warrant requirements of probable cause and go before the...
Well, but Lanfront's a different matter. You've got a pending indictment. I think Justice Gantz's question is seeking information relating to that indictment. You think you get to choose?
No, well, I may not be understanding the question right. I think that if it is a matter where a subpoena is required, that we can't flout matters where a subpoena is required and go get a warrant. If the subpoena is required, we should do that. If a subpoena is not required, nobody has spoken, and no court has said we're required to get a subpoena, then I think if the choice is open, it is appropriate or acceptable to get a warrant. I'm sorry, I don't know enough Massachusetts law to know when particular circumstances are, what the particular circumstances are that require a subpoena.
In this case, you want information. Let's just take the third category now. So we're looking at information relevant to the upcoming trial. Google is a third party. It has information which you believe is relevant to the upcoming trial. Ordinarily, this is post-indictment, you would get a Rule 17 motion, let's say, some sort of motion, subpoena, approved by the court to get that information. Is it your view that you need not go that route? You can just get a search warrant and get it instead?
Under the facts of this case, the court's...
Well, just assuming the only thing you're pursuing is that third category, information which appears to be relevant to the subject matter under indictment.
Yes, I think that's right. And looking to the federal case, the Burke case, which construed the Federal Rule of Civil Procedure 17, it said that Federal Rule of Civil Procedure 17 does not affect the government's ability to go out and get a search warrant, that those are two independent processes. So I would rely on Burke to answer Justice Cordy and Justice Gantz's question, yes.
So do you intend to use information you obtained from this search warrant in the case that's about to go to trial? Or do you at least reserve the right to do so?
I think that we would reserve the right to do so if we lawfully obtained it in the course of executing.
And then what do you do about the fact that you did not have probable cause, you concede you did not have probable cause to search for Category 3? Would that not justify its suppression?
I think it would unless we otherwise lawfully viewed it while executing the lawful portions of the warrant. For example, if in executing the lawful portions of the warrant, a document were to fall within the plain view exception, then in executing the lawful portions we had an exception, I think then it would apply. I would reserve the right to litigate whether it would apply.
Counsel, we're going to have to leave it there.
Thank you very much.